muted.
Kirk is not an attorney. This is not legal advice. This is to be considered for educational purposes only.
Welcome to Kirk's Law Corner Live with your host, Kirk Pendergrass.
Good evening, folks. It's the Rascally Rabbits. Going down the rabbit hole. Thank you for joining us tonight. Let's get this shared out there. We're supposed to have Nathan on here tonight. We kind of haven't really made full contact with him, so not sure if he's going to make it. But we have Christopher Hallett with us with E-Claus and John Gentry. How we doing, brothers?
Outstanding, guys, as usual. Just trying to make sure that he's made it safely to his destination. So making sure that he's all good. And didn't see anything new on the anything bad front. So that's the good news.
Good.
Still trying to, get everything established, see if we can get him on. If not, that's okay. We'll
last time he came on about at the half-hour mark. So.
Yeah, so like I said, we'll see where he is and how things are going as to how it progresses. See if we can get him on.
I can start getting this shared. Share. So, what are we going to talk about tonight? This is the call-in show, folks. So, number is on the screen there. I can't for the life of me remember that number. So, if you got a quick question about stuff, about your case, just about law in general, be happy to answer any questions you got.
Okay.
I'm going to do it through my phone. And they changed so much stuff on this last update on my phone. It's so weird to try and share.
trying to get it to play nice, and it's not playing nice.
Right? I can ever uninstall, because like maybe 2 updates ago, I liked how it was all set up and was able to share the video and that kind of stuff. But now it's like it's all messed up.
Yeah.
So what's your latest over there, John? You got any news for us?
I was talking to the Supreme Court again about doing an original action under Supreme Court Rule 20. And he said he would docket it. So I'm challenging some more unconstitutional laws that are in violation of the Emoluments Clause, the fact that the state no longer enforces perjury statutes, and a couple of bad actors in the state. And I've gone through the district court and the Sixth Circuit already, and they seem to be unwilling to enforce the Constitution against bad actor legal professionals and judges. And so under Rule 20, if you can't get relief in any other court, then Rule 20 permits you to go straight to the Supreme Court. Mm-hmm. So I spoke with the clerk's office today, and they said they would docket it, if it's in good form. And I'm usually in pretty good form in my pleading, so I don't think that'll be a problem.
Well, you just have just the right demeanor there when you go into court. So
then I sent off, in the Supreme Court rules, when you file in there, you have to file in booklet form, and it has to be on 60-pound paper, which is 3 times the thickness of normal copy paper. So I sent them a booklet, just say, hey, take a look at this, make sure it's in compliance, in case I need to send and satisfy Rule 33.1 and file in booklet form. 40 booklets you got to file in the Supreme Court. 40 booklets. That's ridiculous. So I saw CJ's comment, Rule 20. Absolutely. If you've gone to the district courts and the circuit courts and you're not getting relief, raise it. If you have some constitutional issues and you can't get relief in any other court, try SCOTUS. Okay.
Okay. Huh. My phone's still dinging saying it's Sharon, and I put it down.
Right.
Oh man.
I know my inbox has been going absolutely nuts all day long today. More so than usual with everything going on. I don't know if it was related to what I put up on the whiteboard last night, but it's between the phone ringing all day and explaining how all that works and what's it look like on paper. And of course I said, check your email. The legislation is in your box. So, it's like, yeah.
Oh man, I tell you.
But when you show it to them, give them a visual representation of what it looks like. This is not somebody who's just standing here, whining and crying. Oh, they were mean to me. No, this is, look, guys, here's what you're trying to do. Here's why it's repugnant to the law. And why you can't do it. But knowing that it still is a problem and needs to be addressed, here's how we should be doing it. This is in accordance with what the law says. So, as far as that goes, you guys have pretty much already made your case as far as the rights of a parent. The court has upheld that. Look at it this way. There was a case, I think it was Mayer versus Nebraska, was a case about an inmate wanted visitation. And the court upheld that even as an inmate, he had rights to visitation. So, you know, when you're talking about making the argument of time, where's the basis for the attornment of your time? And the answer is there isn't one.
Right.
That's the reason they pull all this crap behind closed doors, right? And, you know, nothing is out in the open. It's, you know, this way they can say, oh, well, you agreed to it. No, I didn't agree to it. You know darn well if you'd have told me this is what you were up to, no reasonable person with half of a brain would have would ever thought that I would have ever agreed to something so stupid. You know, right. I mean, it's like, come on, you know, take your head out of your butt. So, you know, when we have
greater than room temperature in Alaska, you know,
you got it right there. So, I mean, it is what it is. I mean, you know, so basically Congress was, you know, their biggest issue was, what do we do as far as enforcement goes? And I said, well, the answer is what you already laid down about civil contempt, about, you know, certain malpractice. So here's how we handle it. You know, everything is already written in law. I've already worked in the cases, so there's more than enough stare decisis to support what we're saying. So, you know, the only way to protect the seats that you guys are sitting in is to make sure that whatever happens correctly. And when they don't do it, you hold them in contempt of Congress. I mean, it's that simple. So, but knowing and understanding that you can't very well hold them in contempt if you don't have something to replace it with. So I've offered a replacement situation. So far seems to be making all kinds of headway and getting all kinds of traction, because, I mean, looking at it this way, to add the fiduciary element, two things happen. Number one, when you walk in and you pay money for representation to broker the deal, whether it's, you know, getting a divorce or buying a house, doesn't matter. You're paying for the representation. You're going to get fiduciary representation, which you should be getting. And if not, then Congress and the state has a means to hold those actors accountable. So for the attorneys to be doing it, they're not qualified to do it. That's the reason it doesn't work. It's just not. They're not qualified to do that job.
Nope.
I wish it were something, you know, more complicated, but I'm afraid it's just that simple. And so far, Congress seems to agree with that. So, I mean, especially we can walk in with what was the most recent report, 1,400 pages plus of, you know, the blueprint, the supporting documentation, every element of American jurisprudence, you know, blah, 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 blah. And okay, yeah, you're right. You got a point. So, yeah. And we go into the history of you know, the Crown Temple Bar, and, you know, where all that came from. It's fun for Trivial Pursuit, but, you know, when you're worried about getting divorced or whatever, it's no place for it. So,
right. Well, I'd like to just, while we're killing time right here, maybe. Oh, wow. Who do we got? Oh, that's Crystal. Silly rabbit. I'd like to go over the proclamation from December 8th again, and the executive order. And I'll have to try and pull up the latest one. But, right. You know, this is the proclamation from December 8th, 2017. President Trump, when we talk about us reestablishing the rule of law, this is it right here. And the reason why, and I've looked at some of the other proclamations that kind of do this same thing every year. This one's a little bit different. Our president added a few different things to this one. and that is reestablishing the rule of law in this nation, which is our great country was forged in the fires of a revolution to overthrow the rule of a tyrant by a free people who understood the fundamental truth that liberty is best secured when the state's power is carefully limited. From the Declaration of Independence, there it is, to the Constitution and through the Bill of Rights, our country and our people have always known the true God-given nature of liberty and the ability of law to safeguard it against the state. For 226 years, this final piece of this freedom-sustaining bulwark, the Bill of Rights, has formed the bedrock of the constitutional protections every American holds as their birthright. Okay, that's just the first paragraph right there, and that's, I mean, that's pretty powerful right there. Okay, on Bill of Rights Day, we recognize the importance of the first 10 amendments to our Constitution to protecting our liberty and freedom against the inevitable encroachment of government. Our founding fathers understood the threat of expansive, omnipresent government from the beginning of our republic. Therefore, they endeavored to enhance the Constitution with a Bill of Rights and a specific enumeration of fundamental rights that would prevail even against a future government inclined to abuse the power it has over the lives of citizens. That's the thing. We say all the time over there, Chris?
Yeah, due process second, huh? Yeah, no, due process is first.
In a limited government.
Oh, well, yeah, my favorite 4 words, right?
Right, in a limited government. That's what it is.
Right. And
on June 8th, okay, June 8th, 1789, James Madison, originally skeptical of the need for a Bill of Rights, because in the Declaration of Independence, it says our rights are self-evident. I mean, it's supposed to be common sense that we have the right to life, liberty, property, pursuit of happiness, and government is not supposed to be interfering with that. In a limited government, you know, you only have special duties over there. So,
right. DJ's asking something. Executive order I've never heard of. 10834. Have you ever read 10834?
Yes.
I think that's on fitness or something, isn't it?
No, I don't know. About the military being
that's
able to
824, isn't it?
Make arrest. And see, I didn't save here on this computer. Or did I put it on? Nope. Son of a gun.
Yeah.
Oh, I can find it. No, this is the one that's, you know, and it's funny, people need to read it a little bit closer because it's like, oh, well, it doesn't come in until January 1st of 2019. No, only the amendments, everything that's still within the UCMJ there. And let's see.
Isn't that their time frame to, you know, start the process of rounding actors up between now and then or something? That's kind of the way I read it.
The thing is the law. See, this is what I love about Trump. He goes to the law, okay? Yeah. And he says, well, here's a law. This part of the law that he's bringing up and made some amendments to was a you know, executive order or something like that executive order from 1984. So it's been on the books for a while, okay? So let me see if I can get to it because, where is it? I know it's in Law and Justice.
Right.
They don't, why don't they show Law and Justice? I don't get it.
Right. But I did see out in, Washington State, they're starting to go in after they're starting to do raids on people and taking guns over this what was it called, something about a protection order based on somebody's protection or perception of, are you a threat? I'm sorry, but I think that's going way over the line. I think Washington State's going to lose that one ultimately, but hey, they got to try it. And I don't know if it was just fake news or what, but I did see the news article. Somebody was posting it. But
have you noticed that there's been some states that are passing some real funky laws?
Yeah.
And I think this is in an effort, a last-ditch effort to try and screw around with the people.
Yeah, I agree.
Before all this stuff comes down.
Mm-hmm.
This is an area that really concerns me is the laws that the states are enacting, and the ones that personally affect us. People look at, the council comes in there and says, well, there's this statute of limitations here, and so you can't bring suit. And most people go, oh, darn, state laws, statute of limitations, rats, I'm done. And I look at it, and I read through it, and I'm like, well, gosh, that's not constitutional. They can't do that. And it's the same thing, with a lot of court rules. So I just don't accept some of them on their face and say, oh, darn. I look at it, and I read through it, and I'm like, that sounds like an emolument to me.
It is.
And I'm going to raise the issue and challenge it.
Yep.
Talking about a little more current events and what's going on, and California is such a great example of state laws just gone awry. And I'm sure you guys have probably seen in the news, like huge homeless problem out there.
Mm-hmm.
Property prices are a mess. Unemployment is bad. I mean,
right.
They've just, and I'm from California. I grew up there.
Right.
And they have just transformed that state into a dump. And I read there was an article on Fox News today, and the writer in there claimed or made the argument that a lot of these problems are from liberalism that's just gone unchecked. And honestly, I don't think that's the fundamental problem. The fundamental problem is the lack of due process, the unconstitutional laws to allow attorneys to go extort from businesses under statutes that they enact as basically new product lines. They come out with some ridiculous new rule. Like they just did one, no straws. You can't offer straws in a restaurant. And if you do, then you can be fined $1,000 or 6 months in jail or a combination thereof for giving out straws. And they're claiming, oh, we want to keep the beaches clean, keep the environment clean. But they just go crazy with these laws, and there's so many. I'll give you another example. Tennessee enacted one that says if you sue a judge in his personal capacity and he wins the case, then you have to pay his attorney fees. How come everybody else doesn't get that? What's that called, Chris?
Oh, that's an emolument. Definitely.
Yeah, no doubt. That's a special privilege for a person in a position of trust.
Right.
And the people are so uninvolved. They have no idea about the laws that the states are enacting. The people have withdrawn from the civic process.
Right. And here's where it comes in, John. I mean, most people aren't brought into this problem or they're not even brought into it until they're attacked. Yeah. And once they're attacked, okay, how many years do you go through just trying to clear your name? It's been almost a decade, since I got that it took me to get these, final documents that cleared my name. So, it's like, are you kidding me? And now that my name is cleared and I'm not going anywhere, and now they know that I'm in this fight to win it. I'm not going anywhere. That was built for one reason and one reason only: take down the damn corruption. And that's ironically, I enjoy doing it in the corporate world, and I'm going to really enjoy doing it in the public sector. So, it's just a matter of what do we replace it with? And, to give them a comprehensive answer that's already written in law and has been on the books for like ever.
Right.
We just take these pieces and we take this piece and we put it there. We take this piece and we put it there and we put this piece there. Oh, not quite, rotated about 13 degrees there. You go, perfect. And, it's just a matter of finishing what the forefathers started. The science is flawless. It's just, it's missing these pieces. That's why we're tripping over the damn thing. So, and
I want to address Rebecca's comment there that not everyone is as strong as you, Chris.
I just saw that.
We are, and everyone here listening and every citizen of this country can take this fight to these guys. And we're here to help. We're going to do a show upcoming on step-by-step how to file a federal complaint. We're going to do a show step-by-step on how to write the complaint itself. We're going to teach you step-by-step every trick that they try to throw at you to deny you due process. And we're here to help people stand up for their rights. That's what the four of us are on this show for, is to help teach people understand what their rights are and teach them how to fight back for their rights.
Right.
And we'll provide everybody with templates for the work. Pretty much all you got to do is change the header, take out our facts, plug in your facts, and file the darn thing. And when we walk you through the process, it's $300 to file in court.
Right.
400.
Federal court is 300, isn't it?
Nope.
400.
$400 for federal lawsuit.
Yeah, 400 is federal. But
habeas corpus is only $5.
Yeah.
Hey,
yeah,
gentlemen?
I know. It's
yes, Crystal.
What's going on, Crystal?
So, hey, I'm going to hop off here in a few minutes. I wanted to call in and just say, hey, I'm going to our Utah Senate tonight to meet a bunch of our senators, as tomorrow is the last day of the House and Senate in Utah, and we are campaigning for a bill here in Utah tonight that is, we're going to, for domestic violence, that we're trying to get pushed through tomorrow. But I wanted to hop on here, and John Gentry made a really interesting point about, I don't know who was, I'm sorry, I'm driving, so I'm just listening, that, what, if just because you don't think you can do it, Chris, Chris can vouch for this. I didn't think I could do this. I have been in the federal court twice in front of a judge. Anybody can do this. You just have to have the will and the tenacity to do this. I never thought I'd be going to Salt Lake to meet senators, and I am. And that's right where I'm headed tonight. I'm actually a little late for my meeting, hauling butt, but I can only do with, traffic. But, if you really put your mindset that you can do it, you can do anything. Start with your, if you want to be behind the scenes and you don't want to do a lawsuit, find out the laws of your state. Start learning them. And if there's bills that you don't like in your state, campaign for them. That's the last couple of weeks I've taken on a huge burden with that on top of everything else I'm doing to rewrite laws, to help people to better their life.
And we talked about this.
This is another thing people need to understand. Again, it only takes one to go up the federal ladder, and it affects everybody. So,
and that's one of the things that we discussed.
I went down to my local court today and did a court watching. For those of you Idaho here, or maybe even Oregon, may know this gal, Sarah Frank. Okay, she's did 2 years in a row, 2016 and 2017 on the first. Basically smoked marijuana on the frickin' Capitol steps, okay, because of medicinal purposes. And she uses it for medicinal purposes. She's got a serious medical condition there. She has a hard time. I sat there in court with her and watched her today. And I had to beat feet to get home. Luckily, everything nice and local for me. I'm like a mile from everything. My Capitol, my law library, my courthouse. Yeah, freaking even the The federal district court is just even a few more blocks down the road from there, and the Idaho Supreme Court's just a few blocks down. I mean, everything's all right here for me. I'm not downtown Boise, Idaho, capital of Idaho. But I kind of showed the prosecutors and their little interns there, whatever they are, this bar to prosecution in the state of Idaho. And they didn't particularly care for that. And then I mentioned, this is what I was going to get into here is human rights violations and human trafficking. And he pretty much crapped out and I don't want to talk to you no more. Well, of course you don't want to talk to me anymore, because I know more about the law than you do, and I'm definitely more aware of what's going on in this country than you're aware of. So you'll find out soon enough, guys, gals down there, Ada County, whatever, in every state. I mean, it's coming. This isn't just in one area. Worldwide, by the way, just so everyone that watches this after we go off.
And one more comment as well is, if you're having a problem with the judge in your case, look up the judicial complaint and see what complaint you can file against your judge in your case. If you believe that you're being wronged by the judge and you have a substantial claim for it, file a judicial complaint. I mean, Gentry's done it. There's nothing wrong with it. Start doing this. Start calling it out for what it is. The more people that do it, the more we're going to get it out there. Because if you just sit back and do nothing and think you as one individual person can't change the world, well, you know what? $1 from everybody makes 100, thousands on end. It's, you put your cents in for your state and you'd be amazed that, maybe they were just waiting for one more complaint against the judge, or maybe they were waiting for one more, something to balance that scale. You don't know that because you don't know what happens behind closed doors. But if you can get it out there and let people know, hey, you know what? I'm not going to sit back and be quiet anymore.
Well, we discussed this. Remember, Crystal, way back when we first started, almost about a year ago. We talked about getting to this part of the process, and no matter what the court said, we were going to take those decisions and go directly to Congress with them. And that's another thing that, a lot of people get upset and they get frustrated and they say, well, just because they hear no here, well, guess what? There's two other branches of government. And here's the part about it. When the court says no, right? Because guess what? We already know they are. And we take those no answers and we say, okay, Congress, executive branch, guess what? There's no more court action. So separation of powers doesn't exist. Okay. That said, here's what happened. Okay. And here's what you guys said. Here's what they did. And here's the problem with it. And that's the reason, that's the reason that we are where we are. What are we going to do about it? And that's, when I first started this project, I knew it wasn't going to just be me coming and standing next to people in court. I knew it was going to be going and working all three branches of government. Why? That's what I do. And
I want to address Brian Carter's comment. He said, so file a complaint on a corrupt judge to another corrupt judge. No thanks. That's how they win right there, Brian, is that everybody gives up and they don't even try. And they you
self-defeat. But
when you don't do that.
Another thing to put back out here is, again, we have a new administration of government. Things are changing, whether you've been following along or not. We have. Okay, so we're well aware of what's going on with the proclamation, executive orders, EPUB, things that are happening in the background. Okay, so Chris definitely has more privy information on that stuff, but he shares that with us. So, there's some stuff he can't share, but for the most part, he shares what's going on over there in Congress in Florida and how things are, going on in Texas, Utah, Kentucky, things are happening in different places, but start filing complaints against these judges, you know. And I'll go back to when I went to the Supreme Court there, and I was surprised to see that there was no gold fringe on the flag there at the Supreme Appellate Court for state of Idaho. I was actually quite surprised in the mannerism of the people, the whole atmosphere of Idaho Supreme Court down here, totally different than I've ever seen in Idaho. Just about in any court. Of course, I've never been in any of the Supreme Courts yet. Well, I've been in the federal district court before, but you know, that's the thing. When you file a complaint, it actually goes to the the Supreme Court of Idaho. So for your state, the Supreme Court judges look over your complaints. So, you know, try not to say, well, why would I file a complaint against a bad judge in front of another bad judge? Because you can't lump them all in. Right. And I saw firsthand, you know, even the judge there, the main judge down there, he was like, well, in the clear plain language of the statute, you violated this person's due process law. I was just like, I cannot believe that just came out of a judge's mouth.
Right? You just want to
with somebody different as a higher
hit rewind. You got to say that again because I think I missed it.
You know, and going, you know, sticking to this point, because I think this is a critical point where people are afraid. Vanessa made a comment, as soon as I do or say something against my judge, they've retaliated more. Good. More evidence for federal court. Let them do it. And if they've gotten really bad and they've violated your rights, taken your children, extorted money from you under color of law, get into federal court and along with your complaint, do a TRO or a writ of habeas corpus. You know, do something to stop it. And you don't know that what they're doing is retaliation. It may be, but more than likely they're going to do that stuff anyway. Right. And that's just part of the process of depriving you of your rights. Mm-hmm. I can tell you, I honestly believe in my case, and I have a case against the judge that's in the United States Supreme Court, and we'll see whether or not they grant cert.
Hey, you guys, I'm at the Senate, the Capitol, so I will chit chat with you guys later. Awesome show. You guys are getting on the right lines. And we'll talk to you later.
Oh, girl.
Okay, thanks, Crystal.
Absolutely. We'll talk to you later.
All right.
Love you guys.
Love you too.
Bye-bye.
Bye.
So, but I there's a couple of more points about that. Is number one, you're evidencing it in the record. You know, now this judge has a record about the rights violations that he's caused. You know, if you come out on social media and you say, "Oh, my judge is corrupt" or "My judge is violating rights," you're in contempt of court under their perspective, and they can incarcerate you even without jury trial. But when you're pleading in court and saying, "Here's how he violated my rights," and you're making factual statements supported by evidence, you're protected by litigation privilege, and you can say anything that you want in there. And I honestly believe that in my case, I think my judge has read most of what I've written in federal court against him, and I think he's probably has a new perspective on himself. And I think he has a better understanding of the harm and the pain that he's caused. And I think that he is probably going to do better in the future. And so I think I've had an impact on him.
Well, and again, you know, you go back to having a communication with somebody and you say, hey, you know, this isn't right. Here's the law, what it says. And, you know, or you go in and say, oh, well, you're violating the law. You're not going to get anywhere. Yeah,
it's all how you do it. You know, here's what the law says, Your Honor. I believe that our rights are being violated here, that we're not following the law. Here's a memorandum of law proving what I'm saying. And let's get this thing back on track. You know, you do it in a respectful way. I've turned 2 judges hell-bent against me, completely biased against me. But I walk in there very reasonably. I say, you know, here's what the statutes say. Here's what the rules say. and they completely have turned over in my favor with it.
Mm-hmm.
So, you know.
Yeah, presentation has a lot to do with it.
Yeah, just being professional in there, you know, and if he cuts you off, you know, you don't argue with him. You just, you know, okay, Your Honor, we'll address it later, you know?
Yep.
Well, I mean, and it's funny because like I've noticed that here with my local people, and the more hostile that they would get, the more calm, cool, and collected and by the book and the rules that I became. And they can't fight that. They can't, as try as they might to try to piss you off and lead you right down the path where they want to take you. You just don't play the game. You make them play by what Congress said. Here's what Congress wrote. This is what we're going to do. We're going to do what Congress wrote. And of course, when they start with the argument, the blah, 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 they say, okay, well, I can take this information. I can make a report to the Judicial Committee. No problem. And of course, the first time I said that was, well, is that a threat? I said, no, that's a fact. Because one of the things I do is I don't just write pleadings, I write reports. So when I take and I make a report that is backed up by the rules of evidence and other relative documentation, maxims of law, stare decisis, journals of law, I mean, you know, all of this information of, you know, that's relevant. And I put these reports together, and, you know, last one that I completed was like over 1,400 pages. Well, the one I'm working on now for Crystal, where she's going into Congress, is probably going to be almost twice that. And that's one of the reasons that one's taken so long, is because there's just so much of it. And by taking that information and putting that mountain down in front of them and saying, you know what, this is abuse of process on its face. And they go, it is. And well, how did we get there? And they pick it up. And I can go on one page and just go 1, 2, 3, 4, 5, 6, 7, go down the list. And it's usually 1, maybe 2 pages. And they're just standing there going, oh my God. How do you break down, you know, 1,400 pages onto a bulleted point section of 1 to 2 pages? And when you can do that and show them that it's that obvious, okay, that's where you start to make headway. So when it came to doing this with my local people, they're like, well, here's what we need. We need to find out what actually went on. I said, okay, no problem. And I went through and I made the appropriate phone calls, talked to the different people in the agency, said, hey, what's going on? I need something definitive from your office. And that's when these notices of no findings of anything, any wrongdoing at all, when those started coming in and I started dropping those in front of my local judge here, you know, one after the other, they're like, okay, that's it. Time out. We surrender. We're done. This case is unenforceable. Get out of my courtroom. And I said, okay, no problem. Yep. In the meantime, I'm going to work. See you.
Things are changing, folks. You know, you know, this stuff's been going on for how long? You know, it's not going to just change overnight, but I can tell you that there are things coming that are going to be affecting our court systems. They're going to be affecting the bar attorneys.
Yeah, there's no doubt in the last 3 to 6 months, there's more judges that have gone to jail and that have come off the bench probably in the last 6 to 10 years.
Yeah.
You know, so, I mean, the Chief Justice of the Ninth Circuit stepped down under sexual misconduct allegations, and 4 other judges retired in the Ninth Circuit at the same time. Yep. That never would have happened, you know, before this new administration came in. And before the people stood up and said, you know, we want to return to the principles on which this country was founded.
Yeah.
So, you know, absolutely things are changing. No doubt in my mind.
I just want to shout out to Jay Moss from Far From Normal Radio Show. He's in the audience tonight. What's happening, Jay?
What's happening, Jay, brother?
Yep, man. Fantastic show last night. I had a chance to listen to it later on, man. Telling you, guys are on point with it. You are on point with it. Keep up that.
I must have missed it. Well, I know I missed the whole show because I got on.
Great guest. Yeah, they got a great show. They always have good guests on, people that are, you know, working in the trenches. Very informative, great information. I mean, it's, you know, if you're looking for multiple avenues to go, different people to call. I mean, I know I'm plowed. I really am. I'm so busy. I can barely, you know, have time to. You know, I ate lunch today. I just still haven't had time for dinner yet, but, you know, anyway, with Far From Normal, these guys have professionals that are always on the show and they're listening. They are listening. We are getting through. That's another great avenue to go. I mean, go watch some of the old shows. You know, you don't have to wait for the new one. Go back and watch some of their old shows and get in contact with some of those professionals, those guests that were on their old shows. Because I'm here to tell you, there's a plethora of people out there. I mean, this is only one avenue. This is just what I did. So,
there are,
I mean, this may not be.
You know, filing stuff in the federal court, filing writs of certiorari and writs of mandamus or mandamus.
I want to hit on Vanessa's question or comment. She said the prosecutor saying you can't have my evidence for trial, and I'm going to let Kirk follow up with this. But what the tactic that I use to get my evidence in front of the court is I'll file a motion, and along with that motion, I'll file a memorandum of law. Here's what the statutes say. Here's what the state Supreme Court has said, if applicable. Here's what the United States Supreme Court has said. Here's what the state and federal constitutions say. And then along with that memorandum, you say, here's evidence proving that assertion, and you attach an order or whatever your evidence is that you're trying to prove. And you get that file stamped. Now you've got your evidence in the record.
Yep.
And you can take that to the appellate court. And Kirk, I know you got some good things to say about being denied evidence, don't you?
Yeah, it's exculpatory evidence. You know, same thing I was just talking about Sarah today is, you know, the exclusionary rule. Denial of exculpatory evidence, allowing you to enter your evidence in the record to make your defenses. Where did I read that? I think that's like the 6th. You know, you have the right to enter evidence in your defense and make your defense. And if they deny that, I don't know, have a piece of paper there saying you're so-and-so's denying me to enter evidence into the record. Have them sign it.
Well, actually, the fine for
my evidence in, which is it going to be?
The fine for that, for them to do that to you, is found under Title 18, subsection 3571, right? Denial of due process or denial of reasonable defense is $250,000 fine. Yeah, Tony Pellegrino has got a list. I've got a picture of it, and you know, I'm sharing that around as much as I can. And I mean, that's a good place to start. You know, you walk in, say, well, failure to state a cause of action for which relief can be granted. Well, here's what you did. Here's what the law says, and here's how much you owe me, right? So,
and of course, there's rules of evidence.
This one right here, it's in Tony Pellegrino's.
That's it.
Yeah, this is his get up for his deal here. We're supposed to be doing a law seminar this coming Saturday, so I invited him on here tonight. I don't know if he's made it on yet or what he's doing or he's busy. I tried calling him this morning.
Right.
But yeah, that's, I mean, where is that? Denied reasonable defense arguments, 18 USC 3571. That's 3571 just gives the list of what a felony is 250,000. Misdemeanors are this, class A, B, and C misdemeanors. We need to find the actual code that they're in violation of, which would be, you got to look in your state code for the crime. Mm-hmm. Like I said, they've been going through and changing stuff. So in the code now, the fines aren't there. It's weird. All the fines have disappeared out of the code.
Well, of course, because guess what? Now it's like, oh, God, these people have figured this out. Oh, crap. We're screwed. We got to hide it. And that's what they're good at, right? They're trying to hide it. That's why. That's what these attorneys do. Ooh, we got to go sneak in the back room. We got to go hide this.
Essentially, it's all broke down into 3571. I mean, here, shit, I'll just do a screen share. Let me get to it real quick.
Yeah, because there's a couple other ones. There's USC 4 and some other stuff in there too. Good information.
3571 just gives all the fines. It's a breakdown, right. All of it, all in one place, which is actually kind of nice.
Right.
That's it.
Yep. Jessica, correct. Denied witness access, transcripts. All of it. Yep. Every one of us. We've all been down that road. Believe me. And
yep, this is all just nothing but fines.
I'm going to interject something on this one because Jessica's right about one thing, and this was the one thing that royally pissed me off when it finally came out. Because as a man, they won't try half the crap with me that they pull on women. Because they can intimidate women. They can't intimidate me. I don't play that crap. It ain't happening. No. So, but the fact that they do this and they get away with it, it just, I mean, I'm no angel by any stretch of the imagination, and I've screwed up just as much, if not more than the next guy, and I'm not ashamed to admit it. But I can tell you right now, I got a threshold, and that's one of them. And, it just pissed me off. So anyway,
all right,
sorry, so I just couldn't help it.
Screen share. Here we go.
There we go. Go get him, Kirk.
Law.cornell.edu, my favorite website to go on. Okay, Title 18, United States Code, subsection 3571, sentence of fine. So, in general, a defendant who has been found guilty of an offense may be sentenced to pay a fine. See how this is all broke down now. Okay, the amount specified in the law setting forth the offense. Let's back up. Fines for individuals, except as provided in Section E of this section. An individual who has been found guilty of an offense may be fined not more than the greatest of. Okay. The amount specified in the law setting forth the offense, the applicable amount under Section D of this section. For a felony, not more than 250,000. For a misdemeanor resulting in death, not more than 250,000. For Class A misdemeanor that does not result in death, not more than 100,000. For a Class B or C misdemeanor that does not result in death, not more than 5,000. Or for an infraction, not more than 5,000. Now, fines for organizations. This is where it gets fun, okay? So fines for organizations, because they're held to a little bit higher standard, except as provided in subsection E of this section. An organization that has been found guilty of an offense may be fined not more than the greatest of the amount specified in the law. Of course, if you find it in the law and the fine is there, you got to use that. But for a felony, not more than 500,000. That's double. For a misdemeanor resulting in death, not more than 500,000. Whoa.
Something tells me say, no, you're going to pay more than 500,000. Just saying.
Right, so, but this is per claim.
Right. That's if you want a bench trial. Keep in mind, this is if you want a bench trial, right? If you're willing to go with a bench trial and just get it done, you use this, okay? You can also use this as a guideline to show them look, I know what a bench trial looks like. Here it is. And if you want a jury demand, obviously you file your jury demand. But I mean, that's kind of the difference too, because I know it's in there, but it's buried, and it's buried deep. So.
For agencies. So yeah, special rule for lower fine specified in substantive provisions. The law setting forth an offense specifies no fine or fine that is lower than the fine otherwise applicable under this section and such law by, this is just basically telling you to go back to whatever is specified. If it's not, that there is no fine specified, yeah. So, I mean, that's it right there. I mean, everything's all put into one place. So if it's a felony, boom, its maximum is $250,000. So when you do up one of these right here and they look at that, it's like, oh yeah. When they see that, it's like, oh wow, that's violation of oath of office, $250,000 penalty. Yep. Just these simple things, $250,000. Conspiracies 10, extortions 5, but I'd go right, because things changed. I go right back to this, unless it's in your code. And like, oh yeah, wages are taken. Well, here Tony says times 3 equals times 5 times the penalty. Oh, 37 constitutional. Oh, that's 37 counts. Sustained damages total times 3, and then 37 constitutional violations from count 1. This is 9.25 million. So, I don't know, get serious about this stuff, guys. We gotta. There we go. So we do have Darren on here. I'd like to bring Darren on and have him lay some stuff out about what's going on with him and see if we can't discuss his stuff. Are you with us, Darren? You gotta turn your mic on. Oh, he might have stepped away for a minute. I don't know. Wait. All right. You there with us, Darren? I see he turned his mic on. Darren, brother.
He says no sound coming through to you. Oh, there he is. I see him waving.
Can't hear you, brother. You're unmuted over here. I heard you earlier.
Doing hand signals.
Yep, we can't hear him.
Microphone. Okay.
More. Let's see what else. What can I do? Should I make him a co-host?
I don't know if that'd help. I don't know.
Here, let me put you in the waiting room, and then let me bring it back in and see if that.
Yeah. See if that helps.
Can you hear me now?
Yep, sure can.
All right, I just got rid of my Bluetooth. I think that's the problem.
Ah.
And I'm going to have a difficulty hearing you guys, just so you know, as a result. Let me see if I can put you on speaker here and help. All right, let's see what that does.
All right, can you hear
We'll
us?
probably get feedback.
Yeah, I can hear you now. No, I don't have it playing except through the phone, so you shouldn't get feedback.
Okay.
I'm going to dump the video. Yeah, you want to talk about mine. Mine started out with a custody issue. and then turned into a child support issue, and I've been fighting it for 3 years now. They started out taking all but $7 a week of my wages. And, I've done everything I could. I've taken it clear to the Supreme Court of Pennsylvania, and all I get back from them is denied. They won't even hear it.
Yeah.
So, my latest issue was, back in July of last year, I got an order from the court where they brought me in for contempt for failure to pay. And they issued an order saying you have to seek employment, and you have to do it through domestic relations, which is a child support agency for those that don't know. And I told the judge, that's not going to happen because that's a violation of my rights. I have a right to seek employment any way I want. I don't have to do it through you. That's, wrong.
Mm-hmm.
So anyway, they didn't like that. Of course, they issued their order, and I didn't seek employment through them. I returned everything that they mailed me back to them. Wrote return to sender, refused for cause on everything. And then they tracked me down into Walmart parking lot, slipped a piece of paper in my car and told me you've been summoned or you've been served. So I showed up for court on I believe it was the 26th of February. And, I made all the same arguments, where's the marriage contract? Where's the contract that you have that alleges that I'm obligated to pay this through domestic relations, yada, 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 who's been injured, all the good stuff. And they couldn't provide any of that, but it didn't stop them from finding me in contempt and throwing me in jail for 150 days or pay $2,000 fine to get out. So, that's where I'm at. And I had to give up $2,000 to get out of jail and maintain my freedom. And I just received yesterday in the mail an order granting my ex sole custody because I was incarcerated, which was timestamped 3 minutes after they threw me in jail. So, they must have had a plan, or at least from what it looks like. They had a plan, and that's where I'm at.
Yep.
So, the $2,000 that they stole from me is my rent money. So, now I'm going to be hard pressed to find money to pay my rent. And, it's all that's what they do. I mean, that's just what they do. Take. And, even when you do know what you're doing, sometimes it's not good enough.
Mm-hmm. Well, and this was the state court, right?
Yeah, domestic relations, child support court. Yep.
Okay. I'm gonna have to print those orders that we got from the federal case in Utah, because we did get some pretty good direction from them, and one of the things that they had suggested that we do is we file in the state court, that is, but not the family court, the state district court, the
right.
Regular civil court. So, and you just walk in and you cite these deficiencies, and what you're doing is in essence, you're suing the county for every time the judge violates your rights. And by walking in, of course, under jury demand, one of the things that you're asking them to, you're not really asking, you're telling them is, I want this to go before a grand jury. So I'm going to tell you in open court what's going on. And at that point, I want this to be reviewed by a grand jury. Now, why a grand jury instead of a regular petit jury is because a grand jury can order an indictment, right?
Right.
A petit jury does have the ability to do that, but the problem with it is the rebuttals and the pummeling from the other side is a lot more abusive to us and to the process than just going at it from a grand jury. The other thing is in a lot of the cases where you request the grand jury, they're not as likely to be as confrontational with you in front of a grand jury as they are with just you in court. So, because once the grand jury starts to see, that bullying, those bullying tactics and all that crap they throw at you, indictments are pretty much a given. So in the interest of keeping it civil, you're still presenting to a jury, but it's primarily on paper. And one of the nice things about it being primarily on paper is you don't walk out there going, crap, I forgot to mention this, right?
Right.
You can prepare all of your documents, get everything already done. It looks good. It's high and tight. It's clear and concise, supported by evidence. And you don't have to go in there and literally just read it, right? Because that's a lot of what a lot of us do. And it's, they get it, they go through it, and they say, okay, they prepare a list of questions. And whatever their list of questions are, the judge looks through their list of questions and says, looks for the questions of law. The judge will answer questions of law and anything relating to the rules of evidence. So one of the first things that the other side tries to do is they try to exclude the evidence through the exclusionary rule. And one of the reasons why they can't do that is because every one of our documents has our name, address, and phone number, or whatever, right? All of our personal contact info right on it. So you can say to Mr. Prosecutor or Mrs. Prosecutor, how can you try even think about justifying citing the exclusionary rule, knowing full well that the evidence was obtained legally? Because, oh yeah, it's my evidence. And, it's an easy way to defeat it. And believe it or not, when they try it, they ultimately end up looking stupid. So, it's whether they're just doing it to see what you know and how much you know, or,
Right.
They do what they do for any number of 100 reasons.
Right.
But,
I don't even know why they would ask for an exclusion of evidence that you obtained by them. They are the ones that provided it. So
Correct.
how could they even ask for exclusion? They provided it.
Well, same reason as any other trial, criminal trial, because they know a grand jury, the end result is criminal indictment. So what they're going to do is try to defeat the evidence before it gets to trial, the criminal trial, because once it becomes a criminal trial, it's much more difficult to have it excluded. They have to make arguments that the judge is just going to flat out tell them, and the jury's going to flat out say two things. Number one, you can't unring a bell. And number two, if this was eligible to be excluded, it would have happened during the grand jury process. So
Right.
No, you're not going to get that excluded. And believe it or not, that was a problem they ran into with the OJ trial. Remember, if the glove doesn't fit, you got to quit.
Right.
They snuck that glove in there and nobody questioned it. And because nobody questioned it, that's where the prosecutor ended up in losing that case. So, tactically speaking, it was brilliant work on Johnny Cochran's part, but, it's just one of those things that these attorneys are good at. You got to go through and you got to look at each piece of this stuff, each piece of it.
I want to kind of give a different perspective on this, and you guys may disagree with me, but I think when we get into a situation like this, we're being ordered to do, wrongfully being ordered to perform or behave in a certain way. So Darren's example is they wanted him to obtain employment through some process with the court. I think when we get into these situations with these courts, I think we're in damage control, and we try to preserve ourselves, our integrity, our standard of life as best we can as we get through the process, as we go through the process. and we're just in an evidence gathering mode, so when they order you, to behave this certain way, then you say, I object. I don't think you have jurisdiction to do that. I strongly object. I think this is a violation of my rights. You file a motion, or you make sure that you get transcripts of your objection and what the court wrongfully ordered you to do. You comply as best you can, and you gather your evidence, and then you take it in federal court, and then ask them to uphold the law, or you bring it as an appealable issue. So
yeah, I think federal court may be the avenue that I'm going to have to take, unfortunately, and I have requested the transcripts just recently. So
yeah, so the process is you say, I think my rights are being violated here. Here's why I think they're being violated, and I would like you to stop, but I'm going to do whatever you want me to do. I'm going to try to get as much damage control here, so that, like in your case, you ended up getting fined and you had to pay to get out of jail. Jump through their hoops, but then take them to federal court and ask for an emergency stay of proceedings and ask for an emergency hearing and say, these guys are violating my rights. They don't have authority to do that. I would like the federal court to order them to stop. And in that way, you avoid, going to jail. You avoid having to pay to get out of jail, but you still accomplish the same thing. And so I encourage people that I talk to outside of this forum is play possum, give them what they want for now, and then hold them accountable in federal court, and be relentless in federal court. The district courts are more than likely going to be in league with these state actors. Now, you think about this. If judicial oversight agencies were doing their job, misconduct wouldn't occur. If the federal district courts were doing their job, misconduct would not occur. They know that they can get away with it because the federal courts and the judicial oversight agencies aren't doing their job. But that doesn't mean that there's not redress. When you say, you go in and you say, here's the law, stupid, and you got to follow it. And when you prove that in court, and I did in my case, I proved that they wrongfully ordered me to pay attorney fees. They extorted me under color of law, which is actually criminal. I think it's 18 USC 1512 off the top of my head, might be something else. But when they do that, you say, okay, if you want to extort me, here's the money. I'll give it to you, but I'm going to address it later in a federal lawsuit, and I'm going to address it in the appellate court, and then the Supreme Court after that, if you have to. So I think damage control. Do the best that you can to do whatever they want you to do, however unfair and unjust it is, and gather your evidence. Get the transcripts, get copies of the orders, file them in federal court, and get these guys to change their behavior.
Yeah, I'm in the process of getting the transcripts, and I have all the orders. So,
Chris, do you agree with playing possum?
Oh, I love playing possum because guess what? Eventually, they end up popping their heads out of there somewhere, and when they do, you just plug them, and it's in the short run, shutting them down is. Believe it or not, if that's what we have to accept as a win in the short run, then so be it. But ultimately speaking, in the long run, that's where we get them because, they've got no longevity for anything long term. None of them do, and they know it. So, I got to say, one of the conversations I had here locally here just the other day was about my work in my company. And he said, what was your reasoning for, for getting involved in this? And I said, well, knowing and understanding that every term or every contract for employment has a "you're fired" clause. They're like, yeah, that's true. I said, well, the Constitution is no different. It has a "you're fired" clause too. I just found it. And it's that simple. So, because of how things worked out and me being as patient as I am, obviously there's no proof of anything on me, and I've cleared my name. So
I want to really quick. I want to touch on Fatima's comment. Transcripts are always altered. Well, first I'd say no, they're not always altered. They are sometimes altered, I think.
Yeah.
I've personally not witnessed transcripts being altered because in Tennessee, the courts don't record and provide transcripts. I know that happens in several states across the country where the courts record proceedings, and then you can order a copy of it, pay $150 or some small fee, and then they'll give you a copy of the transcripts. In Tennessee, I always hired my own court reporter when I went in, and opposing counsel would always hire their own court reporter. So we'd have three transcripts, one from the court, one from opposing counsel, and one from me. And so that's a way to protect yourself, is hire your own court reporter. Sorry,
yeah, John, can you still hear me?
Yeah, you're a little faded, but I can hear you.
The problem with that is that a lot of us that are in these situations don't have the $400 or $500 that it takes to get a court reporter in there, and we're already strapped. We didn't see these issues prior to them happening. We went in the beginning thinking these courts were fair and just, and that nothing wrong would happen. And then by the time they hit us, it's too late.
Yeah, I know that. I know that very well. I know that story very well. Went through it myself. But I always, if I had to go without food sometimes, I always found a way to pay for a transcript for a court reporter.
Now, one thing about those transcripts deals is it's nice taking notes during your case, but it's also nice to have somebody else there court watching for you who also takes notes. And then when you get those transcripts, if you file an appeal or whatever, you have a certain amount of time to review the transcripts and go, well, wait a minute, this is missing, and this is missing. And you tell the appellate court that this, and this is missing. I've got it documented here. I wrote it down that this is what I said, or I know what I said here, and it's missing. Why is it missing? Oh, well, the appellate court will go, you better get that. So it's kind of one of those, it's the same things. In the first court you go into, they play games with you, it's the machine. Stick you in one side, grind you up, spit you out the other side. But you have to know how to hold them accountable. And again, go back go into that first court. Just know that it's a de facto kangaroo court. They're going to just chew you up, spit you out the other side. But make your record, because that's what you're there to do, is make your record. And again, we go back to, back in grade school, we were taught to raise our hand to be heard. So you got to file your paperwork in order to be heard. That's facts and evidence. And then
Fatima just made a good point too, is if you get the transcripts and they don't look like what actually transpired, get the audio and say, here's a flash drive. I'd like you to give me the audio of this.
Yeah, gotta get your evidence in there, and kind of touch back on what John was talking about earlier. You just file some motion for something and see this and see this, and boom, there it is. Your evidence is in there.
Yeah, getting your evidence on the record is the one of the first priorities of things you need to concern yourself with, and consulting your rules of your court is obviously the first best place to start with that. And even if it is just a separate document, when you come in with a motion for rehearing and see attached memorandum with supporting documentation, and then in the memorandum, you go down, you explain what the supporting documentation is that's attached to it, and you enter those two things onto the official record. So, each state's a little different. And, that's one of the nice things about here is getting information onto the record is not that hard. Right. So, and that's one of the things the attorneys don't like is when you start getting information onto the record. And when I walk in with briefs that are like, and they're just like, oh God, yeah. It's, it's a whole different animal. And, so
what do you think we should, what do you think Darren can do? I mean, they just straight,
I think what we got to do in his case is, because of his situation and he's a little unique, he might be able to go through the United States State Department, through Foreign Affairs, because of the
his separation,
and cite deficiencies in the State Department.
Mm-hmm.
That would be Rex Tillerson's office. So,
and my suggestion would be, that conduct was criminal. That you cannot, a citizen cannot bring criminal charges. That has to be done by the state, by the district attorney, except under RICO statutes. You can, and then you have. I mean, RICO is tough. I've got a really strong RICO case, and I went through all of 18 U.S.C. 1961, 62, 64. Made sure that I met all of the requirements, but it's very, very, very difficult to satisfy and do a valid cause of action under RICO, and so you can't really go criminal. But that is a due process violation, I think, and so it's possible to go under, I think, 1983 when he exceeded his jurisdiction and ordered you to seek employment, through his mechanisms or her mechanisms, which is, they don't have authority to do that. They don't have jurisdiction to do that.
One of the problems, John, is that the statute says in their domestic relations code that you have to be employed at a minimum rate.
So that goes back to
an unconstitutional statute.
That goes back to my earlier point is just because they made a law doesn't mean that it's a constitutional law. And not only that is when you go in and you challenge a statute and say, it's this statute that resulted in my violation of rights. Now you have really good standing to take that matter to the circuit court and to the United States Supreme Court, because that's whether a statute is constitutional or not, that's certainly probably something that the Supreme Court wouldn't mind hearing. Right. And I think it really strengthens a case when you challenge unconstitutional laws.
Yeah, I mean, I can look through their domestic relations code and I can point out a bunch of things that I would consider unconstitutional and violated rights.
There's a ton of them. It's all over the state statutes. The problem is that attorneys will not challenge the courts, and they will not challenge unconstitutional laws because they'll end up getting disbarred for bringing the judiciary into disrepute, which is in violation of their ethical rules. So the average citizen doesn't know how to do it. But I think, between Chris and I and Kirk, we've got a pretty good way to challenge those unconstitutional statutes.
Well, and that's ironic. When it comes to creating a defense, it's bizarre when you talk about the conduct of the actor in the courtroom. And, you remember this, how I wrote this. This was basically to outline the conduct of the actor in the courtroom. I said, you know what? Let's just say all things are equal here. And let's just discuss this conduct. Just the conduct, that's all. And when you go through and you can cite, well, like for example, I got a notice here from Mahoning County, Ohio that says all claims against me are unsubstantiated. Well, why didn't this guy who I paid, thousands of dollars to, why didn't he bring this piece of paper and show this to you? That's bad conduct. That's not representation. Not practice.
I just thought of a question that I asked the judge that you might find interesting. And the question was, does this court have any evidence to support that I have somehow accepted any obligation to domestic relations? And what he said was, no, we don't need evidence. It's statutory. It applies to you.
And that's where he was wrong. Because statutory doesn't apply to us. Statutory applies to them. And that is, if you could get the record of him saying that.
That'll be on the transcript. In
appeals court.
Yeah, that should be on the transcript.
That's a usurpation right over top of the law.
Uh-huh.
By subverting the process. Remember, we talked about they subvert the process to usurp the law, which basically going right around it. And
another thing he said right after that was, I know you claim that the statutes don't apply to you, but that's not true. That's another thing he said.
That's ballsy. Well, he just ended his career with that. He did. He might as well just have took a gun and put it to his head and shot himself when he did that. I mean, it is what it is.
When I get the transcript, I'll be happy to share it with you guys. It'll take a while to scan in, but I'll get it.
Yeah, get me that, because I mean that's a violation of the emoluments, and his inherited emolument. Cite the canon.
I'm pretty sure I can gather enough evidence to dunk these guys deep under the water.
Ulrich, I think it's under Ulrich versus Butler. That was the case where the judge does not have judicial immunity when they knowingly violate the law.
Yeah, I think when they violated your jurisdiction, when they took jurisdiction that they didn't have, and then they incarcerated you, it's false arrest.
Yeah. Looks like we just had somebody join us. I don't know. I don't recognize the number. Did you see that, Kirk?
Yeah, I see. I was just going to try and send you a message there to find out who it is.
Yeah. Don't know the name. Don't know the number. Find out who's on the phone.
717.
Yeah, I don't even see that.
Yeah, I haven't brought it in yet, but let's bring it on and see who. Maybe we got something here. All right, you're on the air with Kirk's Law Corner Live. Christopher Hallett, John Gentry, 3583. Hello?
Hi, guys. It's Alan Schultz.
Alan. What's going on, brother? How you doing, man?
Hey, I'm doing crazy.
I hear you.
I'm in PA also, and I've communicated with Darren in the past, and I've got the same crazy thing that's going on in the court system down here in Franklin County, PA.
Oh, that's where my judge was from.
Yeah, what they're doing is they're dragging me in for contempt of court, and they keep on doing it. How my case started out was I was disabled the first conference level that I had went to. I'd been disabled for 2 years. I had the doctor's documentation. I had the surgery reports. And what they done is they totally ignored ADA guidelines and put an income earning capacity on me from when I was well and strong. I did logging, excavating, construction all my life. So what they done is they put an income earning capacity on me, and then I had a rental on top of that. Then they put the rental, which was my actual income, which was below the SSR, the single sustainable reserve amount. since that wasn't enough for them to garner the Title 4D emoluments, they put the income earning capacity on me and found that my ex had no income earning capacity, even though she was working at the time. So they put this court order on me so that they could get their emoluments, totally disregarding all of the evidence. So I went through a physical capacity evaluation, and finally, of course, I had a Social Security disability claim filed, which took me 2.5 years to get through. And finally, I got the physical capacity evaluation done, and they still continued to ignore my disability all the way up until I finally got through my federal case. In fact, I told the contempt of court judge the first time I questioned whether he had jurisdiction, because I had a federal appeal open in Social Security, which is a federal court, and all that made him angry. Yeah, I definitely got jurisdiction here, he said, and possibly he did, because I'm new at this, and I'm like one of the other guys. I really appreciate you guys with this wealth of information. Is just blowing my mind, because I'm looking at all these statutes and I'm learning all this stuff, and I see all these violations left and right, and it's like, good grief, how are these courts getting away with all this? So the latest is we're in Superior Court. I do have an attorney. I've got tens of thousands of dollars tied up with this guy. He is kind of a rogue in that he's not full bar association. He's a member of his local bar just so he can continue the practice. So he has been fairly well, but we've got cases in Superior Court now. Because the case is in Superior Court, they say they lost jurisdiction to everything but enforcement. So now they are totally neglecting my disability from Social Security now, which was actually backdated 1.5 years before my ex actually even filed to support. So they have that information from the Social Security stating my disability, plus they have all of their information that they denied me due process from day one to establish. For the sake of 2 continuances, they was able to put that interim order on me. What they do is they put that interim order on you because as soon as they can get you paying, they get their Title 4D money, which from what I understand, because of the Bradley Amendment, they don't have to pay that back, because the money that they get in emoluments is money that they can keep. So they don't have to pay that back. So they want to get those interim orders. They want to get you in contempt of court and to get you into their servitude and their slavery. But also, they do that because once they get their Title 4D money, they don't have to pay it back. So what they're going to do now, they won't drop the contempt of court charges against me because they are claiming that they've lost jurisdiction. But now they've actually added new orders onto my contempt of court. And now they're making me sell a piece of property that I have that's held in common with my ex in order to pay the support. So in other words, they're forcing me to sell what is equitable distribution in order to pay their support, because they don't get their Title 4D money in equitable distribution part of the divorce. They get their Title 4D through the support and the spousal support. So now here I am stuck in limbo to pay a $921 a month court order with the threat of continual contempt. They pulled us in a contempt 2 weeks ago, and then they pulled us in, well, actually, it was a month ago. Then they pulled me in for another frivolous hearing on the 1st, and now they run a continuance for another hearing because they didn't get solved what they wanted to get solved. They're trying to say that I lied, because what they've done from the very beginning is they said, you're not disabled, you're not disabled, you're not disabled, even though the ADA guidelines, and then, of course, my doctor's documentation, then their physician's report, but then also the Social Security determination. So now they're holding all of this fact and all of this evidence, and they're saying, we cannot now make a determination. We can't terminate your child support order from a child that's going to be 20 years old in July. Plus, because my wife had no income earning capacity, they don't even want to terminate the order in regards to that, because she has been working on a regular basis. And they also put the additional order on me to now sell one of my properties held in common. And we're back here saying foul, and I'm saying this is conspiracy to commit fraud on the courts, and it is fraud on the courts because what they are doing, domestic relations, like Darren was saying, oh, they're crooked as all get out. They have their own attorneys that will literally railroad you, and that's what they do. They railroaded Darren, and they railroaded me. I had to pay $4,650 to keep from being found in contempt of court 2 weeks ago. And then they try to, well, here's what happened. They said that I wasn't disabled. So they had to put that interim order on me. Now, finally, December 1st, I got my Social Security determination. So now I have this back pay, this lump sum back pay, and they're like a bunch of vultures waiting to get on roadkill. So the judge, he said, well, how are we going to get our money?
Well,
how are we going to get our money?
Alan, I think, honestly, I think Pennsylvania, I think we all need to get together and do what's called a qui tam action. And the reason for that is, you know, their Title 4D is not supposed to be received unless Title 4A was expended. And I guarantee you many of the child support cases in Pennsylvania, like mine, there was no welfare paid for my son anywhere. No benefits from the state or the federal government. That's where Title 4D gets its authority to act. So if there's no welfare ever and never was, they really have no reason to come after us.
And it also Title 4 is for, you know, it's basically for deadbeat dads. But you know, if you're willing to support your kids, they don't have jurisdiction to come in there and tell you how to support your kids, and that's right. That's a big failure of the system too. You know, that Title 4 was when, you know, dads have run away and not accepted, or I shouldn't say dads, but any parent has walked away and not wanted to provide support for their children. That's when that thing should be utilized. But the states have just come to love that Title 4 money. And
well, so, another thing, John, just in my case alone, I brought to the court's attention, I have my son 44% of the time. During that time, I provide food, clothing, shelter, and anything else that's necessary for him. And the judge said, well, that's above and beyond your financial requirement for domestic relations.
Yeah, because they want your money.
It's exactly about the money because the judge even said on the bench, he said, well, how are we going to get our money? And then he had the nerve. See, they said I was disabled, and until the point in time that I had that lump sum payment, now they're claiming that now I have income and they're jumping on my disability pay. So as far as my son goes, the support was for one child who was 18 years old, who was a homeschool kid, and subsequently she flunked him out to get another year of child support, and that's kind of why things are the way they are. But the problem is now is that I'm stuck in this limbo because, and they hate the fact that we have them in a superior court, and we have so much evidence against them in regards to what needs to be done. But also, my child being almost 20 years old, it's obvious that he is to be terminated from support, which they will not do, and it's obvious because of my disability that backdates a year and a half even before my ex filed. There's the hard evidence that should terminate the order altogether. And there's the hard evidence that my son's going to be 20 years old, so he should be emancipated at 18. But also what plays into this now is that they are finding me in contempt of court for monies that Social Security has now paid out in derivatives to my ex in regards to my son. Mm-hmm. And in my opinion, that's Social Security fraud. They can't have it both ways. They can't be finding me in contempt of court for monies since they backdated my Social Security disability. My ex has now gotten derivatives from that money. So what they're trying to do is they're trying to argue the fact and try to find me in contempt of court, stating that that somehow or other we lied about when exactly we received that lump sum payment by a day or 2 days or something. I think what they're doing is they're trying to brand us They're trying to brand myself and my attorney to and for the superior court so that they can make us look like we're criminals. Yeah, we got a 15-day suspended jail sentence here. We got a 30-day suspended jail sentence here. We've got contempt of court here. I think they're branding us because this is frivolous and vexatious litigation that has no end means to it.
You are
They absolutely branded me.
Real quick question, and then Chris wants to jump in here.
Okay.
Did the court assign any realtor to sell your property?
No, they didn't. They just stated that I was to have it listed for sale by March 15th.
Well, that's good because, you know, big problem up in Connecticut is the court will assign a realtor, which is generally in relation some way with the judge. And then, you know, they get a fat commission. They do a terrible job on selling the property. And you're the one that, you know, they sell it at a loss or they sell it cheap. And then the realtor takes a commission and, you know, and that's a typical scam that they run. Yeah. But thank goodness in your case, the court didn't assign.
I could see that. I guess my question to that is do they even have legal right? They say they lost jurisdiction to my case, but do they have the legal right to even do that?
No. No, they don't. Why? Because every bit of it, and I mean every bit of it, is one form of an emolument or another. And I mean every bit of it. And if we're looking at this process, and I've shown this to Congress.
I think we lost John and Kirk both.
And
nope, we're still here.
Yeah, they're
still there. Okay.
Okay. Now, what we've done is, and I've been to several policy meetings already where I have explained what due process is perceived to be. This is this is in black is what Congress has written. Okay, exclude the 4D. But information flows both ways, right? Well,
yep.
What's actually happened is what they have in effect done is they've changed the direction. Instead of it flowing both ways, it only flows one way, right? All the way around this whole process. And this is the, you know, pick an agency. To use John's example, where they assign a realtor, okay? That realtor is given a guidance document, okay, to provide the service. So he's going to claim a service, okay? So that's how the realtor is going to get paid by the targeted parent. And the 4D funding comes from behind the bench here, which of course we already know. And so basically we've got money here. We've got money in an agency here. If you got a DCF case, you got money in an agency here. And every one of these agencies, and last time I knew there were, 63 of them ish. So this is just a small representation of the 63, every one of these. Some you don't even see. And every one of those agencies tags in, right? And that's how they collect these millions of dollars every year, is whether the agency of, Park Services is involved in your case or not, it doesn't matter. They are tied into this entire mechanism, and there's no management process of it. So the only thing that they have done is they have changed the flow of information to literally go right around you, right? So instead of you being able to rebut, okay, you're not rebutting anything. You're standing over here. You're the target. You got all these layers around you, and there's nothing you can do. You're a torn at this point, okay? And they have literally surrounded you and making you run through all of these hoops they got you distracted with this service and this service and this service and so on and so forth. And they'll just tell you about the ones that that they believe are going to be able to do the most damage to you and screw your head up. So you're not paying attention to where the money's going, right? So when I went through and I explained this and I said, this is what's called a malicious design, and it's repugnant to our form of government. And they said, yes, you're absolutely correct. How do we fix it? And I said, the problem with it is we don't have an equalized practice of law. And here's how I figured that out. You got, like, for example, in my case, in my Utah case, you got this information coming from this guardian ad litem person, right? And neither one of our attorneys even attempted a defense. So we're going to we'll call this the defense process. Okay. And anytime a defense was attempted, doesn't matter what it is, this part of it is punished, right? And we have definitive proof of this because in Utah, my client was declared a vexatious litigant as the respondent, the defendant. Wait a minute. The only one, according to the rules, that can be declared a vexatious litigant is the person who brings a frivolous suit. So explain how you just found a respondent who is presenting a defense as a vexatious litigant. And that's where they're stuck right now. And that's where we're at on appeal. So, that's why you said I've literally taken in her case by filing my reporting and severed this part of the connection, right? And through my reporting mechanism with the negative nexus, I'm going back. Oh, sorry, guys, got to move you. Going back all the way back around, but not to the court. I'm going up here to Congress. So I'm like, haha, psych. And I'm taking all of this information, every bit of this, because I figured all of this out. I know where every dime of this stuff went. And I'm writing the report right now. The one I just finished in Nate's case was 1,400 pages, and this one's going to probably be twice that. So when they see this, and it's all emoluments, every single bit of it. So that's where we get the overturn and the reversal of all of this process, and we can take and effectively cut it off right there. Because the original affidavit of truth was false. So in the negative nexus, conduct of the attorney, the actor, we were able to definitively show where that was 100% a PS and BS, as I like to say. And now the only ones connected to this process, it's not my client, because guess what? We went and from all the money, now it's all coming back around to Congress, and that's where we get our contempt.
One of Darren's famous lines right there is, so-and-so over there is attempting to enter facts on the record that are not in evidence.
That's right.
Objection. And basically from that point on, going back to what you were just saying there, the attorneys don't want to do that. They won't do that because they're there to attorn you. So get rid of the attorney and start doing this stuff yourself.
And it's not just opposing counsel. It's very often your own counsel is part of this process.
Right. Well, and the reason your counsel's part of this process is because their rules of practice have literally, even though you've paid them, they've severed that connection to you. So this person's just kind of, defense counsel is just kind of, I'm just here for decoration. I'm just here for show. I'm not connected to anything, right?
Yeah, it's just enough. They give the appearance of a trial when it's mock trial.
Right. That's exactly it. So when I cited that in my original judicial report, because obviously I spotted this before I spotted anything else. And I said, well, Sonoma Beach, here's how we're going to fix that problem. That's when I started the audit process and discovered all of this garbage. Yeah. That sucker was over 2,000 pages, just the audit, nothing else.
I caught on early. I had one attorney for a few months, and I was like, "You're obviously not acting in my best interest here. You're fired." And I had another attorney for another couple of months, and I was like, "Here we go again." So I guess it's time for me to represent myself.
Mm-hmm. And that's where we're stuck.
Not by choice. I didn't want to represent myself. I just didn't have anybody who would do their job, you know?
Right. And there are actually plenty of good actors that know this, and they can't speak up because guess what? Like this guy, if they do, what happens to their practice?
Yeah, disbarred.
They get disbarred, right? They can't wave or salute. They're just as stuck as we are. So, you know, ironically enough, this was where the policy meetings came in. And when they finally started to confess this, it was like, okay, not only is this is not about, yes, I was right, ha, ha, ha. This was about, okay, this is where we're going to unscrew it. So I said, here's my suggestion on a way to unscrew this that will allow you guys to still make some money while doing it, while unscrewing it. And we'll give you a due process, an equal protections due process. The Congress has already written. What do you think of it? And they went, sign me right up. Hell yeah, I'm already paying how many thousands of dollars a year, and I can't do this and I can't do that, and it's gotten to the point I can't even defend a client now. I mean, you got to understand, there's these good actors that there's more of them than there are bad actors. These good actors are more pissed than we are, because guess what? They went to school for a long time, worked very hard to obtain a really good reputation, and a lot of them have it, and they're earning it.
Yeah,
but when it
had a torn people, it's funny. They keep talking about this law stuff. Well, the law says, in this hearing that I was at today, I was talking about, she showed the video and stuff. Okay, so she was a passenger in the vehicle, and brake lights or something wasn't working. You just rental car or had it for 5 days or something and got pulled over. And then the next thing you know, he's getting pulled out of the car, and then they're up there, I'm going to smash your window in if you don't get out of there. Well, for what? Well, we're going to bring a dog in because that's our policy.
Mm-hmm.
And I tried to explain to her on the side there a little bit, but it's kind of a little bit late. But I gave her questions to ask to pull him back up on the stand later and said, hey, where in the law does it say that you can trespass the Fourth Amendment? Where you're claiming that you can do this and you can do this and you can do that. You're law enforcement, right? You're deemed to know the law. Where in law does it say what you say? Well,
right. And they can't show it. Okay.
I didn't get to stick around long enough for her to bring him back up on the stand because she was still presenting her witnesses and stuff. But, I saw the video, she's like, hey, I'm invoking my rights. You got to have a warrant. She flat out telling him you have to have a warrant because and then threaten her with, I'm going to bust the window out. And you're going to go to jail for resisting and obstructing. Where's your lawful order? Where's your warrant? Where's your power here? You don't have any authority. Again, what I cannot do in my person, I cannot do through the agency of another. So can I walk up to next to your car and pull a guy out of the driver's seat and then walk around the other side of the car and say, get out of the car? We're going to run a dog around the car. And I go, you can't be there. It's my policy. It's my policy. Yeah, it's called a guidance document. And get the memo from Jeff Sessions that put the kibosh on your guidance documents being used out here, and you're using them as law. I guess you didn't get that memo. But I'm kind of curious how it turned out, because I watched the jury, and this is the crazy part again. Oh, we only got a 6-man jury.
I carry it with me.
6-man
I
jury.
do. I carry that memo with me. I've got copies.
Rights.
I carry in the van.
That in all capital or criminal prosecutions, a man has a right to demand the cause and nature of his accusation, to be confronted with the accusers and witnesses, to call for evidence in his favor, and to a speedy trial by an impartial jury of 12 men of his vicinage, without whose unanimous consent he cannot be found guilty. Right there in the law, in our ideology.
Well, I think that lays out part of the problem, in that they don't know the law. They want to pretend they know the law, but they know their statutes, or they pretend they know their statutes, but they don't know the law.
Yeah, they don't.
They
So
know the law quite
that?
well. They know the law as well as we do. They just choose not to follow it because it doesn't suit their wallet.
No, they
doesn't fit their agenda.
Well, again, it doesn't fit the indoctrination process that's been shown them in their guidance documents, right? So now we've got this cultural conflict of interest between what the law says about domestic tranquility and what they've been had shoved up their ass about social control, right? And
exactly, that's they're bar educated.
That conflict is right where we are right now.
Yeah.
And that was by design. It was by design. And I just, I walked in and I showed it to them. The law that you guys are breaking is called an emolument. I know you haven't spoken that because you've skirted that word for 230 years. Well, guess what? Not anymore, pal. And how I asked the question was, I said, okay, knowing all of this, how the hell are we supposed to protect our inherited emolument, meaning the seat you guys are sitting in, when you're acting a fool?
Gee, why are people getting booted off of our video?
Oh, probably because we're pissing off Facebook. I said E word, nah, 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 nah.
We're going to pull this plug and drain the shithole. It's coming.
A lot of them are bar educated. There's things that I've learned off of you guys that my attorney has no idea what I'm even talking about.
Right.
I was down there January 10th talking to an old public defender, and I was telling him, I'm like, hey, where the proclamation, the rule of law has been reestablished, the Declaration of Independence, and he's like, oh, well, the Declaration of Independence isn't law. And I pulled this out and I said, when's the last time you read this? He looked at me and I said, this is Great Seal State of Idaho, published by our own freaking Secretary of State. I'm like, this isn't the first one he's put out. That says Declaration of Independence. That's the law. No. I said, you want one?
It's the supreme law of the state.
Yeah. So
again,
I started handing them out.
These people have no freaking clue. I gave Sarah one today. I brought one down. I brought a couple of them just in case they wanted to, here you go. Judicial notice. I'm putting you on judicial notice of all of this right here, because this is the law. Not your statutes, your rules, your regulations, your policy. This is the law. And so if anything that you bring up statutorily wise that's repugnant to this, or let's say, well, it would be repugnant to this. Let's say you just don't have that authority because, like parental rights, okay? Idaho Code, they're deeply rooted in our nation's history and protected by the 9th Amendment. Oh, wait a minute. Let's see what that 9th Amendment says here. Well, let's look at that. Other rights retained by the people. But then what's the 10th Amendment say? Well, the 9th Amendment says rights retained by the people. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Now, the 10th Amendment, rights reserved to states or people. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, which there's a prohibition there in Article 1, Section 10 of the states, are reserved to the states respectively or to the people. Wait a minute, there's powers reserved to the people? Yeah, damn right there is. And it goes back, we'll look at the Ninth Amendment again. Parental rights are protected by the Ninth Amendment. And in my Idaho code, it says among the unalienable or unalienable rights. That takes you right straight to the law of nature because we're creations of God in the Declaration of Independence. And that public defender down there says, well, Declaration of Independence isn't law. What the hell? What rock did you just crawl out from under?
Yeah, dude, I hate to be the bearer of bad news. That's been around just 1 or 2 years. I mean, just one or two. And
it just blows my mind that they can even think that the Declaration of Independence isn't law. You look in Black's Law, at least in my 6th, my 10th has changed, or my 9th has changed, but in the 6th edition, it says law, definition. That which is laid down, ordained, and established. Well, that one's been laid down as the law. This has been ordained and established, and the Idaho Constitution's been established. It says right in the preamble. Exactly.
That's because they're taught statutes in their schools. They're not taught the law.
That's exactly it, Darren. They're bar educated. They're bar educated, so they are learned in their statutes, and they're learned what they do. They follow orders. They don't follow law.
Yes, man. That's what they are.
Order followers.
Yeah.
So here's a preamble for the state of Idaho. We, the people of the state of Idaho, grateful to Almighty God for our freedom, to secure its blessings and promote our common welfare, do establish this Constitution.
It's hilarious because, when people actually, pick that sucker up and they start looking at it and they start reading it and they're going, I was right. Oh, thank you, Lord. I was right. And it's then the reality sets into them of, okay, here's what it says. How the hell are we doing this? And that's, like I said, number one, when I tripped over the emolument thing, literally almost fell on my face. It was like, hey, who put that there? And said, okay, well, I know what this is. And I started to look at the elements of the practice, which is, again, as a practitioner, that's what I do. I study those parts, as the parts guy. I want to, okay, what's that part? That part right there. Okay, that fits right there. This part over here. Okay, that goes right there. And I started to put this thing together, and based on American jurisprudence, and then compared it to what the bar model is, and said, "Oh, hell no! This is what we're supposed to be doing. This is American jurisprudence based on a law. Here's what the repugnant bar thing is doing, and that needs an overhaul. We need to take that sucker, crumple that up, and throw that bastard in the trash can." And
just grab a case of these from Secretary of State every once in a while. Just head down to the courthouse, grab my little pad of paper, and go sit in the back corner. And when I get up, I'll just leave a couple of these on the pew.
Right.
Start reading it.
Well, again, Nick asked a good question. How the hell do they think American Republic came to be? And the answer is, Nicholas, they don't even know. Remember, they're taught the stuff that they're taught when you're looking at like liberal universities. They're taught that America is bad, right? It's social control is what you should be. Socialism, social justice warriors, social. That's what they're taught. Okay. And while all of us, myself included, were at work, funding the, keeping the mechanism going, we got these actors. I'm just going to call them actors just because I don't want to end up off on another rant. They're subverting the process, right? And calling, us for fathers since the 1950s, fathers have been everything but a white man, and, or whatever in my particular case only, but it's like, whoa, time out a minute. Yeah. I don't, I smoke and I drink a lot of coffee. Ooh, oh man.
So, how many of you out there have heard this? We're a representative democracy. What? How the hell did you come up with that twisted term? Let me read the Constitution of the United States of America for you. Article 4, Section 4, guarantee of Republican form of government and against invasion. The United States shall guarantee to every state in this union a Republican form of government and shall protect each of them against invasion. And on application of the legislature or of the executive, when the legislature cannot be convened, against domestic violence.
Mm-hmm.
When they say that, Kirk, I say, don't include me in we, because I don't know who we is.
What we?
We who? I don't know anybody named we.
This is one that astounds me. So in the U.S. District Court, bringing suit against the state, my Constitution, like yours in Idaho, I think Florida is similar. It's a little bit different. It says I have an unalienable, indefeasible right to reform the government in such manner as I think proper. Doesn't even have to be proper. As long as I think it's proper, I can demand reform of the government. Does the government need to be reformed? Well, I think there's a lot of evidence that it needs to be reformed. There's no due process. We can't enforce our right of due process. The states have enacted laws to usurp due process. They've enacted laws to protect corruption. The states provide no oversight of their judiciary. Yeah, there's a whole lot of reasons that we need to reform the government. Right. And the district court judge comes back and says, well, that doesn't mean you can sue the state.
How about the First
The Seventh Amendment did you miss, bro?
It has refused to dispense the laws the most wholesome and necessary for the public good.
Right?
Our law. We laid down.
Blackstone was, right? He's the Crown's counsel, right?
What?
Something like that. Blackstone. He was like the Crown's counsel back in the 17th, early something. And it was well established. Jefferson has said the same thing. Where there's a legal right, there's a legal remedy. So when the Constitution says I can reform the government, that's a legal right, isn't it? And so there has to be a legal remedy. And for the district court to say, now that doesn't mean you can sue the state. Obviously, she's wrong. But we'll find out. Hopefully, we'll see what the Supreme Court says.
How about he has erected a multitude of new offices and sent hither swarms of officers to harass our people and eat out their substance.
That's exactly it.
Yeah.
Yeah, that's exactly what they're talking about there, right there. Back in 1776, don't tell me they didn't know about, tyrannical form of government, because they got it written down right here. Some of the ones that we went over last week, for depriving us in many cases of the benefits of trial by jury. That's what's written in the Constitution, both in Article 1, Section 9, the federal bills of attainder, and Article 1, Section 10, that back to the 10th Amendment, the powers prohibited to the states.
Mm-hmm.
Section 10, Article 1, Section 10, bills of attainder. That's legislation that prescribes punishment that bypasses your rights. Right there, for depriving us in many cases of the benefits of trial by jury, declared act of tyranny. That's like
nothing new under the sun.
Go into traffic court.
Nothing new under the sun.
I went into the protection order hearing there on February 1st. Okay, well, I'm going to demand my right to a trial by jury. Oh, you don't get one.
Mm-hmm. Oh, dude. And here's what I did.
What planet are you from?
The statute
here's what
doesn't
I started
allow
doing.
for jury trial.
Yeah, you're right. I know.
And one of the things that I do, just because I'm me and I like being a jerk about it, I've started sending these notices. Notice of denial. Wow. Signed. Prevention. So, because it all boils down to the money in the end. So it's like, okay, well, when the banker says no more money, that means no more money. Crap. So, now they're stuck. They don't know what to do, because they're like, well, this and this. And I says, no, you said here, the 11th Amendment. Oh, no, you said here. They said that. Oh, no, here was the case you cited. Oh, no, here's the case you cited. Well, that was supposed to be. It's what you said. So.
Yeah, that comment just made by Jackie Kahn. Those that don't know their rights effectively have none. And
right.
This is why we are here. This is why I started doing Law for Dummies on Blog Talk Radio over a year ago. That's why it's Kirk's Law Corner, because over here in the corner, see, I got some law here. I'm wanting to share that with you, and I'm trying to tell you, get out there and read this stuff because you got to read it. If you don't know it, you can't effectively claim your rights, and then
right.
you can't effectively defend your rights. So after you read this stuff, then you got to start reading the rules of procedure. And then, John's got templates and documents and stuff that he's got written up. I've got some templates and documents written up. Chris has got over there. Amber and Steven, it's a group.
Yep.
Facebook group. That's where we're and some John, examples. I've got some stuff in there. So get out there.
Nick just brought it up. I'd love to see the notice of denial. Okay, Nick, I'll go ahead. I'll remove the personal information off of some of these, and I'll just put blanks in there so you guys can kind of have an idea of where the emoluments violation, right? So when I hit them with the denial notice of an emoluments violation, that's it. Shuts their shit show right off. And I'll get some of those put together and get them posted PDFs in the group for you guys. So, you guys can have a little fun with them. Blame it on me. I'll take the blame. I don't give a shit. What are they going to do? Come knock on my door? Yeah, come on in. I got coffee around here somewhere. You want one? Yeah.
Well,
that's great of you to do that for us, Chris, because we can glean a lot of information out of what you've already done.
Mm-hmm. Yeah. Well, now that I'm to the point, I can actually, I'm done with it. So now I can start sharing what I've learned, and I don't have to basically put anybody else's information out there other than my own and say, okay, here's what it is. Here's what I did. And here was the end result. Shut them down. You're done. You're denied. You're out of here.
Well, the potential for that to multiply tenfold is amazing. I wanted to ask you guys about a Commonwealth states. The Commonwealth states, how do they differ from the other states in regards to dealing with common law?
Ask Darren.
Neely would be the one to talk about that, because I think Kentucky is also a Commonwealth. Is that?
If you look up the root of Commonwealth, it just means republic.
Oh, okay. So then would
they
it be?
They try to trick you.
Oh, so Commonwealth would mean the same thing as republic.
That's what I found in my discovery, is that Commonwealth actually means republic.
Is there any advantage? Somebody was telling me there was an advantage that I'm in a Commonwealth state in regards to actually coming against them in defenses.
Well, this is what, if you call any of their agencies, they think Commonwealth means we get to steal your stuff for the Commonwealth of us.
That's good.
Yeah.
They'll make up anything, won't they?
It's bad, but it's good.
They tell you what the law is, and unless you go read it for yourself, they're just going to continue to tell you what it says and cram it down your throat and attorn you. Yep. So you stand up for yourself. I mean, again, new era. Grab that proclamation. Grab the executive order. Like I did today. You guys aware of that executive order from Trump the end of December there? Human rights violations and human trafficking. I don't even want to talk to this guy anymore.
Yep.
Yeah.
Bailiff, make him stop talking to me.
Yeah.
Well, I like Chris's allegory about the clicker. He says you get the statutes out and you get down across them and you get your clicker out and you just start clicking.
That's right, man. Get it out there. Start counting.
Yep. Click. So. Click. All right.
The problem
folks.
is getting the judges to even listen. They become so much of an egomaniacs over the years that they don't even want to listen.
Well, again, back to the first court that you go into, just you go in, you automatically know, okay? I'll flat out tell you, they're admiralty jurisdiction, military tribunals, Article I courts. You're not going to get justice there. You're going to get over here with that equity scale that Chris shows all the time, okay? So file your paperwork, raise your hand to be heard, put your evidence in, make your record. I don't care what they do. Just like what I told this gal tonight or today. Just do your thing. Just know that they're going to railroad you. Make your record, okay? Get out of there. Go to the next court. You know, unless you, for some magical reason, you end up with some justice there. But, you know, make your record, get your evidence in there, in and on the record. You speak it. You got to speak it. Grab the law, speak the law, and don't let them rile you. Just make your statements. Know what you need to say. No, you know, write this stuff down. Exactly. I mean, pull the law up, write it down. This is what I need to say.
Yep.
And don't let them rile you. Say what you need to say and just shut up.
If you don't know what to object to, here's one that you can always throw in, and it's a blanket one. I object to this unlawful attornment.
That's good.
Seriously, say again, I object to this unlawful attornment.
I'm going to use that this coming Thursday, I believe, Chris, because I got a contempt of court hearing coming up Thursday.
Right. So, and
prove the element of intent.
To tell the judge that you're a Republican, Donald Trump is his president, and well, where did it go? And is president, and you will listen to the law as it is written.
Tell him you know this guy.
Okay. I'm not going to tell him I know Darren. We'll be sharing a cell with Darren.
Yeah.
Love you,
no,
Darren.
I'm not in there. I'm not going back.
Common man can understand it. Just answering John Patton there. Had an attorney tell me that I can't interpret the law because I didn't go to school. I'm not trying to interpret it. I'm just reading it as it is written. Got a problem with that? Deal with it. Over there in the corner.
Yeah.
If it's not written,
And no,
it doesn't need to be written.
That's why I said, you don't understand the King's English. Do not consent to this unlawful attornment.
Yep.
Hey, do I get property rights for that statement?
What's that?
I said, do I get royalties for you guys keep saying that statement to me?
Which one?
The King's English one, the one we were joking about yesterday.
Oh, no, that came from me.
Yeah, that came from
That
a long time ago.
Yeah.
Well, no, because, you know,
I got it from
every time you guys laugh about, hey, the judge says you can't interpret the law, you haven't gone to law school. Okay, so I just spent an hour and a half with senators who are writing bills. And guess what? These assholes are not. They are not attorneys. You know? And these guys are the ones that are writing the bills. They're not attorneys. They're not schooled in the law. But I just spent time with these gentlemen who said, you know what? These guys we tried to write a bill that is so plain in English that any lay person, remember that word, Chris, can understand these bills.
Yeah.
Yep.
Well, that's again, we go back to what I posted there before and showed on Monday night, the Law of Nations. There's certain limitations, such as the fundamental law, this Declaration of Independence, Bills of Rights. The legislative branch doesn't have the power to create legislation regarding the common law. You can't codify the common law. Only the powers that are delegated can you codify. So on that note, we're out. Thanks for tuning in tonight.
Oh, sure. I just get out of my meeting and you guys were done. Sure.
Well, hey, we're over now.
Well, hey, thanks, guys, as usual. Appreciate everything you guys are doing.
Absolutely, Alan. Good to finally talk to you, brother. One of these days, I'm going to get freed up from all of this monstrosity crap I got going on. And we're going to be able to have a conversation. So.
All right, ladies and gentlemen, thanks for tuning in tonight. Chris, John, you guys carried the show tonight. I was just beat. Like I said, I was up 5 o'clock this morning, down at the courthouse all frickin' day. Barely made it home at frickin' 5:20. Just in time to pop on here and say hi to Ted and have a smoke, and then the show started. So, yeah, I'm on.
Well, we're glad you got pretty fight for us.
4 hours of sleep, so.
Right.
So, thank you all for tuning in. Much love, John, Chris,
Yep,
everybody else out there.
Yep, absolutely, guys. All the time.
Shout out to Ted Fogg, who produces over there. Love you, brother. You do such a great job for us. And
yes, he does.
Ted, can you turn your mic on? I know you got some stuff that you're doing, the Nancy Schaefer stuff, and.
Yep. All right, I'm on. Yeah. So every day.
Your mic is on out there.
Yeah. Can you guys hear me?
Well, I can hear you.
Yeah, I got you.
Here.
Yep. It's on. So, if you don't know about the event yet in Georgia, the first annual Remembrance of Nancy Schaefer event in Clarksville, Georgia, it is this month, March 25th. It'll most likely be going on all day, but the main part of the event will be from noon until 8. You can watch me every single day, every weekday, 5 days a week at 5 o'clock. I do an hour show in promotion of the event. So just look out for that. It'll be shared different places. If you have any specific questions, the best time to ask is during that show. I get so many messages. Facebook notifications are astronomical. I don't even pay attention to it. Messages get lost as well. So call me or watch the show to get some questions answered. I appreciate it, guys. Wait, you're muted, Kirk, all of a sudden.
And that's on the March.us page. That's Ted's page over there.
I'm broadcasting that right
Eastern time, right?
I'm broadcasting that right through my own profile. It might go on the March Us page. But that page has changed to Multimedia Broadcasting Services, actually. I'm trying to offer this as a service, hopefully in the future, to all kinds of different mediums.
Way cool.
Yeah. So if you're interested in that, if you have an idea and you have a show that you want broadcast everywhere, let me know. We can work something out.
Excellent.
Thanks for letting me plug those things, Kirk. I appreciate it.
Hey, you need to get it. You're doing some wonderful stuff over there, some great stuff. So I tried to mention that last time, but your mic didn't come through.
That's okay. You know,
so
we'll get there. Trial by error, right?
Yep.
Do you have to use the word trial?
Literally.
Sorry. But a couple last things I want to say. Never did get hear from Nate. He must have been stuck on the road, so I'll try to get with him, find out what happened. Also, don't forget, tomorrow night is Restoring Families Internet Radio Thursday night. See Brian Lee, Steve Ball. They'll be back on Sunday. Then you'll see us Monday. Tuesday is Far From Normal Radio Show with Jay Moss and crew, who made a guest appearance here in the comments section tonight. Then you see us back again here when we come full circle on Wednesday. So on that note, anything else to add, John?
You know, you guys have heard, freedom doesn't come free, and it's the same thing with your rights. Stand up to your rights, educate yourself. You know, Kirk has said it, Chris has said it, learn the rules, learn the law. You know, my second or third trial, I said, hey, could I respond to that? And the judge said no. And I said, Your Honor, that's a violation of the Code of Judicial Conduct. You know, I didn't even know what the Constitution was at the time. And you know, I've come a long way since then with help from people like you guys. You know, so keep seeking out people like Kirk and Chris and Ted and Jay Fox and all those other people out there, and take their knowledge and stand up for your rights.
Beautiful.
And that's it, brothers and sisters. Let's get it.
On that note, we love you guys.
Love you guys. Have a great night.
Take it easy.